SJC-12562, Commonwealth v. Pedro Vasquez.
Okay, Mr. Bennett, I guess you go first, even though you won some, you lost some.
Correct. Good morning, judges. May it please the court, I would like to begin with the Miranda issue and then move on to the video identification and the CSLI issue in conclusion if there's no objections to that order. Beginning with Miranda, I'd like to begin that argument, Your Honors, by addressing a contention raised in the defendant's appeal that Judge Agostini had credited some of Dr. O'Loughlin's testimony, which would be problematic for our arguments here. And I'd like to address that by first stating Dr. O'Loughlin was about 80% of this hearing. He testified over the course of 2 days, and in a 20-page decision, Judge Agostini does not cite to his name once. In fact, in footnote 11 of Judge Agostini's decision, he makes it very clear the evidence that he's looking at when making his review of the Miranda. In this case, I'm simply reviewing the official transcript of the interview as well as the video presentation, and that's on page A101 for the Commonwealth's appendix.
Yeah, let me stop you there. So the expert speaks about the defendant's command of English and his understanding of legal terms. Does the judge have to make specific reference to it in the decision for us to say that it's pure de novo and that we're going to essentially ignore it and treat it as if that evidence never happened?
No, he doesn't, Your Honor. I think there's more contextual clues in Judge Agostini's decision. For example, when he cites what he believes the Miranda warnings or the translations were, he does not use any of the language cited by Dr. O'Loughlin, obviously.
So, but are we supposed to do that analysis? I mean, now we have to decide whether it's pure de novo or whether or not we recognize that there was testimony with the credibility. Are we now going to be essentially to deconstruct what was in the judge's mind when the judge decided it, or are we to recognize that there was testimony which bore on the issue and that suffices to say that we're not in a strict de novo world?
My contention is that we are in a strict de novo world, Your Honor, because the evidence that is cited by Judge Agostini, who does make specific credibility findings of some witnesses, is based entirely on evidence presented in the video and transcript rather than Dr. O'Loughlin. And as I'm sure the court's aware, Dr. O'Loughlin had many more translation problems than Mr. McDonald did, yet the judge specifically finds on Mr. McDonald's translations. In addition, the defendant cited to 3 specific instances where the court should find that Dr. O'Loughlin was credited, and the first is the fact that Mr. Vasquez is illiterate, and that is not entirely sourced from Dr. O'Loughlin's testimony. In fact, Mr. Vasquez states it himself in his interview on appendix page 172 of the Commonwealth. He states, that's why he doesn't know street names that well, because he can't read or write. It was also testified to by Elix Rivera, who has known Mr. Vasquez for 23 years. The second example, Your Honors, would be that Judge Agostini states that
He point to those people as having been the source of his finding?
I'm sorry, Your Honor?
Does he rely on either of those people expressly for his finding?
No, he does not.
So we're as free to say that he relied on the expert as not, right?
I'm sorry.
We're as free to say that he relied on the expert as the 2 witnesses that you say he relied on.
He is. The contention made was that it was solely sourced, and I'm simply pointing out that it was not solely sourced.
Have you ever, do we have another case where do you have a case, as a matter of fact, where we've ever done anything like complete de novo review when a judge has heard evidence?
I don't believe so.
I don't think so either.
Very well. And I would just point out the third category, that the contention is that the judge credited Dr. O'Loughlin's findings on gratuitous concurrence, and I can say based on the transcript that that is not what happened. Dr. O'Loughlin's testimony as to gratuitous concurrence was his explanation for why Mr. Vasquez would answer yes, he understands things, give verbal responses, and he states it's because it's a phenomenon when people will answer yes even if they don't understand, because it is the safest answer, and then hope that they will understand as the conversation goes on. Dr. O'Loughlin does not attribute this to the nods. In fact, he denies that he saw the defendant nodding. What's important to note here is that he's saying yes and agreeing with statements that are being provided to him in Spanish, not a foreign language. And that's what he's indicating his understanding to. Judge Agostini, when making the determination that the nods were not affirmative responses, simply attributed them as merely indications that Mr. Vasquez was listening. That is not adopting the language of Dr. O'Loughlin, and in fact, he's applying it to the nods rather than the verbal responses.
Well, even if he's listening, if the warnings aren't proper or correct, and if the warnings don't adequately convey the information that needs to be conveyed in and of themselves, there's a problem, isn't there?
Absolutely. And I will address that. I just wanted to begin with Dr. O'Loughlin and pointing out inferences that the court can draw there. This case, it seems to be, the Commonwealth versus Vuthi Sang decision seems to be the defendant's main contention here, and that's a case where two sets of warnings are given. One is defective or incomplete, and the language they used was, and the circumstances are such that the defendant would be confused by the discrepancy or omission. That is not a voluntary, knowing, or intelligent waiver. In Sang, the court found in those circumstances that the defendant was given his proper English rights, but in his native language, he was given something completely diametrically opposed, in so much that he was told that he did have to speak with them and had to answer truthfully. The only time he should not speak is if he didn't understand the question, and he was never, in any circumstance in his native language, given the warning that anything he said could be used against him.
What do you think he would have understood from the first right that he was given?
And the right to remain silent, Your Honor? I would suggest that based on Mr. Vasquez's own translation of that, that he did understand that warning, because the word he provides, when Officer Ortiz seems to be reaching for the word or struggling to read the word, Mr. Vasquez provides the word callado, which means quiet. And I would suggest that that's probably the most
All
critical
right, well, what
word.
about the second one?
In the second prong, Mr. Vasquez, actually, it's not in the transcript, but I do have the moment in the video where he's receiving that right, and he says contra at the correct point, knowing the word for against. Also, Mr. Vasquez, after receiving that right in English, before any translation, Detective Kennedy asks, okay. Mr. Vasquez nods, not during the statement of the warning, but at the conclusion. He nods vigorously, and then he reaches for the pen to sign the initials next to that warning.
Doesn't the expert address that point?
He does. I would disagree with Dr. O'Loughlin's testimony that he's simply following along. I think there's a little...
But the expert did say that.
He did.
And so the judge could have relied on that in making this finding.
He could have, but that's not what he says here. In fact, he relies on the translation being so garbled and removing the Spanish language words from that translation that it would have been confusing. But I think there's a lot of merit in the fact that Mr. Vasquez, at the appropriate point, was able to provide one of the more critical words of that warning, against. Now, there is the issue. I'm sorry, Judge.
No, excuse me. Mr. Bennett, these are all reasonable arguments that you're making. Some of them are actually quite good. But what we're doing now is we're trying to understand this. How well does he understand English? How deficient, if at all, was the translation into Spanish? And we're trying to take a look at all of this and decide whether or not the Commonwealth met its burden beyond a reasonable doubt. And it seems to me, with all these issues at play and these credibility issues at play, that just looking at the tape de novo is not, when we have all this testimony, is not going to allow us to see whether or not it was error to say that this wasn't proven by the Commonwealth beyond a reasonable doubt.
Understood, Your Honor. If I can address his English comprehension first in response to that question. This is a 94-page transcript, and the Miranda warnings take up about 20 pages. And in looking at the totality of the circumstances about how well Mr. Vasquez actually understood English, there are 4 instances outside of Miranda where Officer Ortiz has to actually translate a question for Mr. Vasquez. There's only 4 instances of that, and I do have the citations for that. But essentially, the other times you'll see Officer Ortiz in the transcript is when he's either translating what Mr. Vasquez responded in Spanish or when he's asking clarifying questions about his response. He essentially answers every question posed to him by detectives, including when it becomes a little more hostile, aggressive, and confrontational about the video. He answers those all without translation. Sometimes he responds in English, sometimes he responds in Spanish for more accuracy. So the question here is about his English comprehension. And when we say his understanding was replete throughout the video, that's what we're talking about. The fact that he only required the assistance of the translator for 4 questions outside of Miranda, and he listened to the Spanish translations for Miranda, because after he nods at the end of the second prong and it goes to sign, Detective Kennedy says, well, listen to him first and then sign. So he's instructed to do that, and he follows those instructions. But his ability to understand English is very evident throughout. Now, as to the sufficiency of the warnings, I would suggest that there are no issues with the first prong. He is able to provide the word, which, if we're looking at Dr. O'Loughlin's testimony, is actually just as forceful as the word silent. He says that it's a term that could be used to not talk, or a term that could, or somewhat of a rude term, to keep your trap shut. So he understands the critical rights involved in that.
Isn't there a difference, though, between being able to translate a word from English to Spanish and understanding the concept that underlies the Miranda rights? I mean, I get what you're saying, that he understood silent, he understood, other words within the warnings, but that doesn't necessarily prove that he understood all of his rights, does it?
Not in and of itself, no. What I'm talking about, I think the context around what the word he provided when Officer Ortiz is struggling after he recites per mansir to remain, and then it's Mr. Vasquez that's able to provide it, I think indicates, number one, he has an understanding of that right from the English version that he just received. The concept of the word remains the same. He has the right to not speak with the detectives. When we move to the second prong, Your Honors, I would suggest there is visual evidence on that video of his understanding of the English translation of that right. And then the translation, the issue there would be, rather than say in court, it says of the court. And I would suggest that a minor variance like that does not distort or contradict the right that he's been given. In fact, he's been told in English, suggests he understands, and then he provides the word against, and at the end, the court is still mentioned. Now, the literal translation, I believe, was the of the court, or something to that effect. So Mr. Vasquez is still informed that he has the right that anything he says can be used against him in a matter relating to the court.
Can I shift to the second issue for a second? Say we don't agree with you on the first issue. I just don't understand how we can find the consent to be proper when he doesn't understand the questioning. How do we, if you lose on the first issue, how do you win on the second one? I don't see how the judge did that.
Are you referring to the consent of the sir? No, and we've conceded that. If there's a Miranda violation here, then the consent is over. That's out.
If we can follow up on that. So if the consent goes, then we have to strip the affidavit of all that occurred during the course of the interview, including his statement about giving the telephone number. So tell me how you salvage the probable cause for the CSLI without that. I gather the phone was seized before the interview.
Yes, Your Honor. Now, obviously, the statements that he made would have to be excised from that. However, while not stated clearly in the affidavit, there is mention that they did obtain an administrative subpoena for his telephone records. Now, they're raising the issues being raised in the defendant's brief now that should be excised as well, but that was never raised in the lower court, and it's the affidavit or the subpoena for that information doesn't come or is not before this court.
Well, how did they get the phone number for the subpoena?
Yeah.
Well, if this was to be remanded for a lower hearing, there was independent information. Number one, Mr. Vasquez provided his number at booking. Number two, they got his phone number from family members as well. So there was independent sourcing for the administrative subpoena.
I'd like to ask a big picture question about the CLSI. So there's nothing, as I recall, in the affidavit that's particular about testimony or inferences that the defendant has the phone with him, or that the CLSI in this particular case is going to tell us something about location. And the question is, if you agree with that, what are the implications? Is it enough that cell phones are so ubiquitous now and that people are more than 5 feet away from their cell phones, that the historical requirement of particularized facts in a warrant don't apply in this circumstance?
No. If the court does not find that there's any information that it can use to show the location would provide an access to his cell phone, then it's out. It doesn't change. The ubiquitous nature clearly does not suffice for probable cause in this case. My response to that, Your Honor, would be the fact that in the affidavit, when they describe going to his house, well, there's two things that I want to address. Number one, they raise, without much specifics, the fact that he's been leaving threatening phone messages for the victim. Then we move to the circumstances of how the phone is actually seized. And it's brief in there, but they go to 28 Newland Street, which is his residence, And when they find him, they arrest him there, and the phone is, they say, physically on his person. So the only argument I can make there is that the fact that it was on his person when he's in his own home, I would extrapolate the facts to say the home is the most likely place where a phone would be placed on a coffee table or in a bedroom. This is the same day as the murder occurred. The phone is physically on his person. If he were to walk outside at that point, the phone would also be outside.
How would you ever demonstrate that there's enough for somebody to have a phone if we didn't accept that inference?
If you don't accept that inference, then I can't.
How about, you have 30 days here. Why we need to justify 30 days, right?
Yeah, Your Honor, I would agree that under the case like Commonwealth versus Broom cited by the defendant, the issue they had there was not actually with the probable cause that was given. It was the probable cause didn't apply to the entire time frame. And I would have to concede that we do not have probable cause for 30 days. I think if the court was to accept my argument about the phone being on his person later that day, physically on his person in his home, then it would really only apply to January 5th.
But I'm confused. If you've got it for 30 days, we have the constitutional violation then, don't we? We're not able to compress it to the time necessary, are we?
I would suggest, since it was the subject of a motion to suppress, that the 29 preceding days could be suppressed.
Yeah, but we still have a Fourth Amendment violation. You don't get to keep the one day that's useful, right, under our precedent?
Then I would concede that issue, Your Honor.
I'd be careful about doing that because I think our case law says that if you do not, that the mere fact that if you have 30 days and you look at only less than 6 hours, that spares you from the need to find probable cause. But I don't think we've addressed the issue that you just were discussing with Justice Kafker as to what happens if you have PC for only part of it, but you do have PC for the one day.
Correct.
Can I turn you, I know your time is up, but can I turn you briefly to the video?
Certainly.
Would it be your intention or the trial counsel's intention at trial to obtain from those witnesses an ID that says that is Mr. Vasquez, or are you going to limit the inquiry to the person who is fleeing the car is consistent with what Mr. Vasquez looks like?
It would be that he's consistent with what Mr. Vasquez looks like because based on their identifications, that's what I'm confined to. And I would suggest, looking at the video, this is one piece of evidence that the officers, by necessity, had to break into two parts, because if they show the video portion at the same time, all those witnesses can recognize the Jeep, and they would know what they were looking at. In this instance, they wanted them to listen to the audio first. I would suggest that, in fact, in Mr. Osvaldo Hernandez's identification and Elvin Cardona's identifications, they specifically cited having heard his voice as one of the reasons they're saying that's consistent. But they have the requisite familiarity as found by the judge, but they also have the familiarity with the dimensions of the Jeep. It was Jairo Hernandez's car. They're familiar with that. So that Jeep is actually what forms the backdrop for this figure that they're identifying by his size and his dimensions, as well as clothing, which is peculiar to him. I want to say they're not overselling this. They didn't identify those as Nike Air Force One sneakers. They said they're white sneakers consistent with the Nike Air Force Ones that he always wears.
Okay, so that would mean in practice that you'd have to frame the questions to only elicit from them that that person is consistent with how he looked, as opposed to that's him.
Absolutely, because they all agreed they cannot see his face. So it's not an identification of his face. They list the factors. Abigail Martinez says it's his silhouette, the way he walks, the clothing is consistent with what he wears. But through no fault of the police, obviously Mr. Hernandez and Cardona looked at this all as one piece of evidence and
Yeah,
said,
but
based on his voice.
when you're trying to weigh probative value and undue prejudice, so what you could have without that would be they recognize the voices and have known him for a long time, and then we know he has these type of clothes, and then the jury sees the video, or that's one option, or you put in the consistent language, and then we get into weighing probative value and undue prejudice under Johnson. And it's not just looking at what you have, it's looking at what you could have had, and then the incremental addition of the ID being consistent with, that we weigh against undue prejudice. So I'm not sure you get enough so that it's not unduly prejudicial with the extra testimony.
My response to that, Your Honor, would be the fact that I think it is important testimony that it is consistent, because they listened to the audio first. Had they listened to the audio and then we have a figure on the video who is morbidly obese, inconsistent with Mr. Vasquez's stature, I think that would go against the reliability of that voice identification.
Isn't this the trial judge's job?
Certainly, I think this is more akin to a motion in limine than a suppression issue at this point.
The balancing should be done in the lower court.
Especially because this court would be at a disadvantage for not seeing what Mr. Vasquez looks like today as opposed to that time.
Okay, thank you. Mr. Schnipper.
May it please the court, I'm Merritt Schnipper for Pedro Vasquez. I'd like to begin with Justice Budd's comment about the difference between the translation of the term that's used in the Miranda warning and the concept underlying it. And I think the most important fact that Judge Agostini found, although he did not reference its source specifically in his decision, he didn't reference any witnesses other than those who testified on the identification issues. So I think that's kind of hazy about, discrediting witnesses based on their non-mentioning. But the most important thing he sourced from Dr. O'Loughlin was the idea that the defendant speaks street English or can function in many circumstances, but struggles as the conversations migrate into more complex concepts. And then, of course, as part of that testimony, he testified to the Miranda vocabulary test he gave to the defendant, and his determination was that the defendant understood only one of 8 words that he was tested on. So it's exactly the idea of the legal concepts underlying it, which both is where the rubber meets the road in terms of whether Mr. Vasquez was adequately given his warnings in English, right? And then, of course, we have the confused warnings in Spanish. And the problem here is that, we have a person who's basically making the most important decision probably of his life, but certainly of this interview, right at the beginning with these translations. So the fact that when it's, well, where were you at 5? And he seems to be functioning in English, or he says, yeah, I know, cansado or callate, I know what these mean. Right, okay, so he's feeling his way along, and there's every bit of evidence that he's lived here in the mainland for a long time. He can deal with quite a bit of English, but we're talking about whether he understands the consequences of speaking to the police when he's under arrest and charged with murder, right? That's what's at issue. And I don't think that the government, there's no doubt that the judge is not, whatever he put in his footnote, he's acknowledging, right, to the extent that I'm making a decision based on a video, I'm really just saying one thing and the reviewing court's gonna take a look at it, and that is true. But it's also true in Novo and Clark and all these decisions that the court has issued that when a judge is reviewing a video, but is reviewing that informed by testimony about which he or she has made credibility determinations, that gets substantial deference. And I think it's that point of deference that really decides the Miranda issue, and thus, as the Commonwealth has conceded, the consent issue as well. So unless there's specific questions for me on that, I'd like to move right to the CSLI first, which I think is a really important case for the court's CSLI jurisprudence, because this, and I would have to disagree.
Could you answer, because back and forth between me and the chief, I just want to make sure, I'd like your take on that. So if you've got a 30-day CSLI request, which you don't have probable cause for the full 30 days, do you get to keep the 6 hours?
No, you don't. The court has been clear, and it's either in Broome, Fulgham, or Estabrook, and I'm afraid that I can't tell you off the top of my head which, that says you have to justify under the probable cause standard whatever you get. It doesn't matter that you just use the lesser amount that you could have gotten.
So if you asked for 30 days and didn't have probable cause, then you don't get to use the 6 hours, right?
No, you don't, right. So you don't get a little Stored Communications Act order carve-out, right, even if you fail to establish probable cause. And I would strongly disagree with the idea that this warrant made out probable cause to seize any amount of CSLI, because while he did have his phone on his person while he was at home arrested, he might have been wearing his bathrobe when he was arrested. That doesn't support the inference that if he went out to the store, he would necessarily wear his bathrobe to go there.
Well, we're not talking about going out to the store necessarily.
No, we're not.
But isn't it a reasonable inference in the circumstances of life today that people usually have their cell phones with them?
If we're just talking about common sense understandings, it absolutely is. The difference is what is a reasonable inference in the probable cause analysis. This court has already said.
That's different?
both in Morin and White, that you're not going to be allowed to use common sense inferences about contemporary cell phone use to invade the contents of a cell phone, then the question becomes, is there a different standard for CSLI? And I would argue that, I mean, in Carpenter, the Supreme Court said CSLI is even more intrusive than GPS
But it
monitoring.
didn't the Supreme Court also in Carpenter in deciding whether or not to give, to make, it'd be a warrant requirement in order to
Correct.
get it in the first place, to basically be saying that the cell phone was a proxy for the person.
They did treat it that way, although I think
So
one
if
of-
you have it for that purpose, isn't it kind of odd to be saying differently when you're talking about probable cause to get the warrant?
Oh, sure,
He's talking out of both
right,
sides
so
of
they're
your mouth.
saying it's treated as a proxy for the person, and what we're saying now is, okay, so now do we have as a matter of law that if there is probable cause to believe you committed a crime, we're automatically accessing your CSLI because as a matter of law, that can be treated as a proxy for your location at any given time. So I think there's two very specific and dangerous issues with that. The first is that it represents an abandonment of the requirement of articulable facts based on specific information for a probable cause. And I can't think of another instance in which this court or the U.S. Supreme Court in a regular criminal investigation context has abandoned that.
So it's a proxy in some circumstances, but not in others.
Well, I mean, the most telling line, I think, and I agree that the Carpenter decision does not adequately address this issue or address it the way I'd like to have seen it done in terms of this proxy question. But the most telling line in Carpenter is that CSLI is a proxy for the holder's whereabouts. They use the term holder, which is an interesting concept to use because obviously when you think about commercial paper, all these other things, you know, there's a separate process that has to be used to identify who might be the holder of a particular object at any given time, right? You know, and what I point out sort of just towards the end of my CSLI argument in my brief, and I think it's a very important issue, is let's just assume, and it's useful for this argument, that the content of this CSLI is not in the record before the court. Let's assume for a second that the CSLI shows that Mr. Vasquez's phone was at his Newland Street address at the time of this homicide. Presumably, the Commonwealth is not going to say, oh, we got the wrong guy. I'm sorry, folks, this is a mistaken prosecution. The evidence clearly shows that the matter of law location of this individual was at his home at the time of this homicide.
Would that be fodder for the defense?
Well, I mean, it certainly could be, but the point here is that why does the government, on a simple showing of probable cause to arrest, get entitlement to access locational data that it can use as a argument for guilt regardless of what it shows? Because obviously if it shows he's at the scene, he's in big trouble.
Doesn't that apply to all evidence?
I think it's a little bit different if people are allowed to treat a phone as a proxy for a location, and then the first thing the government turns around and says is, well, look at how smart and premeditated this guy was. He knew he was going to be tracked by his phone, so when it was time to go out and commit a murder, he left it at home. Now, I'm not saying they can't make that argument. What I'm saying is to be allowed to access evidence that gives them the power to make that argument, they need to make a showing of probable cause under the traditional substantial
But
basis standard.
what about judicial notice? Not only what the Supreme Court has said, what we've said in Augustine and other cases, but really, is it subject to reasonable dispute in the jurisdiction in which the court sits that the overwhelming majority of people can't seem to get more than 5 feet away from their cell phone without freaking out where it is?
Use it in their shower?
In the shower?
Oh, yeah.
Evidence that the 20% of people, or some high
They have some
percentage.
sort of baggie they put it in, or maybe
I don't know,
that-
if in the shower or near the shower, they take it into the bathroom with them?
Wow. I mean, I just think that,
Yeah,
so what
I
I
know
would
it.
struggle to find is a meaningful line at which this sort of assumption doesn't just simply eliminate the requirement of specific articulable
Well, no,
facts.
I'm not suggesting it does at
So
all.
it's just
I'm not suggesting it does. I'm suggesting that courts can take judicial notice, and the question, not the answer, really, is it any more? It's embedded in the Supreme Court's Carpenter decision. It's embedded in Augustine. Is it really subject to reasonable dispute in the jurisdiction in which the court sits that at this point in time, that most people can't even be on one screen anymore?
Well, I do think I think it's subject to dispute about an individual, just the same way the court has said, we're not going to automatically associate drugs and guns. We're not going to
But
automatically
it's not,
associate
but it's not subject to dispute when you argue expectation of privacy to us. And you say that this is going to capture the mosaic of someone's life.
I'm saying it has the potential to do so.
Right, but and really, isn't really, there's some duplicity that we're concerned about when we've recognized and everybody's recognized on expectation of privacy, we've thrown out the third-party doctrine because of
Right.
it. and we've said, this is a glimpse into a mosaic of someone's life, you need probable cause. And then, on the other side of the mouth, you're saying, but my guy didn't have his cell phone with him, you can't prove he had it with me. But I thought we were trying, that's the mosaic of his life.
Well,
So
I'm
how
not
do you
saying-
explain that duplicity?
Sure, let me try. First of all, I'm not saying he didn't have his cell phone with him. What I'm saying is the government hasn't put any facts in the affidavit to suggest that he had his cell phone with him.
Didn't they say that it was on him when he was arrested?
Yes, in his home. So, of course, another thing we've
So
taken
that's something.
judicial notice of through Carpenter and these other decisions, that many people use their cell phone instead of a landline. So they have their phone at home because a phone belongs at home. I mean, that's another way to look at it. And I'm not trying to be facetious here. What I'm trying to say is that we've rejected this, you know, we're feeling our way into like a new era of technology and surveillance, and we're trying to understand the limits
Well, and
of
speaking of
privacy.
that,
Yes.
feeling our way into a new era, at the time that the police applied for this CSLI, what was the state of the law in the United States and in Massachusetts?
At the time they sought the warrant, well, Augustine had issued and you needed a warrant under Article 14. Carpenter had not issued. You were good with the Stored Communications Act warrant, but obviously here we're pre-trial. Carpenter comes out. And one thing that I think that's very interesting about Carpenter and is relevant to the brief period around the homicide itself here is that I'm not sure that the Estabrook exception for 6 hours survives Carpenter.
All right, well, let's talk about exceptions. We don't accept an exception for the good faith of the police officers in the exclusionary rule.
Correct.
And we haven't, ever. But in this circumstance, where we're dealing with such new technology, and as you mentioned, we're all feeling around, there's nothing the police did here that they wouldn't have thought was totally proper.
Well, I mean, we always look at the four corners of a warrant affidavit and decide if it establishes probable cause, so there's nothing new there.
Right.
Right. So in terms of what they did, in terms of their treatment, their Miranda issues, or the warrant they issue? I mean,
warrant.
Yeah, they believed they had gotten this information legitimately. They put it in a warrant and they submitted it to a magistrate who issued it. So they didn't do anything wrong in that sense, right? But what they didn't do is include specific facts that supported the probable cause to believe that this CSLI would be relevant to his location at any particular time in their warrant affidavit.
Is there evidence that suggests that the CSLI may be relevant because they've got this domestic abuse, ongoing domestic abuse here, and we're trying to figure out motive?
Well, one of the problems is that there's no dates associated with the allegations of abuse or threats. So, you know, it's very difficult to So, I mean, you could go, I mean, here's another interesting fact about the CSLI issue here.
But just play that out for a second. So if there's probable cause to believe he's committed the crime, which I'm sure you're disagreeing with, but...
Well, I mean, there's testimony that people recognize his voice in
So
the video.
I'm just trying to understand, when we have this history of domestic abuse and we're looking for a motive, we don't get any time frame here? I'm just trying to get a sense of...
We don't get any time frame, but when we're looking for motive, obviously, we're probably looking for content of
we're looking for
communications rather than
text.
locations, right? We're looking for content.
Okay, so the CSLI is not going to give us anything on content.
That's right. And I would mention that there's a digital extraction by the affiant of content.
There's no
but it's-
stay-away order here in this case?
No, I mean, there's a question of a warrant, affidavit that she submitted for a 209 order. That's all we've got. We don't have a
Can you go
stay-away
back
order.
to the answer you were given to Justice Gaziano? Because I'm really interested in the whole point of how you reconcile the position on privacy and the position on whether or not there's probable cause for the CLSI. And so you were saying why the duplicity is not dispositive here.
Well, what I'm saying is that there's two things that I think are relevant. The first is that if his so, you know, if you look at the Augustine warrant discussed in this court's decision, the Balboni case from the appeals court, these warrant affidavits set forth specific instances of the use of a phone to make a call, to send a text, at times relevant to the crimes under investigation. So we know that knowing the location of the phone at that specific time is likely to provide evidence of the defendant's location because he or she did something with their phone at that specific time. That's one set of CSLI affidavits that you could imagine creating probable cause. Another set, and this is really relevant because CSLI there's no exigencies involved with CSLI. It's a historical record that's already been created. It's in the hands of a third-party corporation. There's no danger of destruction, and there's no need to timely access it to prevent something happening in the future or to investigate a crime that still may lie ahead. So there's plenty of time to speak with people like the Hernandez family that the government was working with to actually say, is this an individual who carries his phone around? Does he text you frequently? Did you receive any text from him on this date? I mean, the types of questions that a police, I think, are pretty used to asking in the course of an investigation that can build a warrant that actually satisfies the probable cause requirement. I think that's why the notion that somehow applying standard probable cause requirements to this new type of information is either going to impede the truth-seeking function, prevent investigation of crimes, or somehow give people a get-out-of-jail-free card just simply isn't true. It's different type of information. It requires a slightly different type of investigation and presentation in a warrant affidavit, but it's there so long as the facts that could support government access to it are there.
But the probable cause is probable cause to believe that there's evidence of a crime in the CSLI data, correct?
Yes, that there's going to be evidence of the crime.
And if the evidence of the crime is that your cell phone happened to be there at the scene of the crime at the time of the crime, would that not be evidence?
Well, right, but what we have,
The Commonwealth would have to tie up the fact that it was more than the person's cell phone who was there, but that's certainly evidence.
It is evidence. So the question is there any substantial basis to believe, based on what we see in this warrant affidavit, that the cell phone was there at that particular time?
It's certainly evidence that the person committed a crime. That's something for trial in terms of the inference that the person had it. But
I think what we're asking about is the more basic question of what does this affidavit contain that suggests that if his phone was there, that meant he was there, or that if he was there, it means his phone was there.
And I guess my point is that if his phone is there, that certainly would be evidence of his involvement in the crime. It may not
yes,
be
I agree with
determinative of it. And
No, I agree.
isn't that all that you ask of a search warrant, is to find probable cause that you will obtain evidence of a crime?
Well, right, but the difference here is that all we have evidence of is a suggestion from these video IDs that he was present. We don't have any suggestion that his phone was present. So unless we're treating the fact of his presence as creating probable cause to believe his phone was also present, because the CSLI data can only tell us the location of the phone at any given time. So some connection needs to be drawn between his person and the phone before you satisfy the probable cause requirements in a warrant.
Can I turn you to the 30-day argument?
Please do.
Your position is that if the Commonwealth can show that, they only were justified to get 24 days, not 30 days, that everything goes, everything is suppressed?
If the Commonwealth had probable cause for 24 days versus 30 days, I think you'd have an interesting argument. If the Commonwealth can prove that we had enough for a Stored Communications Act order of 6 hours, but not for a warrant, I think we're talking about apples and oranges. So I agree, you could have a de minimis issue. Well, you really only justified 28 days, you got 30 days. I mean, I could see the court parsing that. That's not this case, because if there's probable cause for anything, there's probable cause for everything here.
So there's a search warrant for a home, and you say you're authorized to search for guns, for drugs, for pornography. Court says you actually only had PC for the guns.
Right, well, then any space that a gun
that
couldn't
means
fit,
that
you couldn't look, right? I mean,
But you do have PC for the guns, so the guns come in. You may manage to say, I'm going to suppress the pornography and the...
right, but I mean, the correct analogy here is where you're allowed to look based on what you're looking for, right? So if you have probable cause for guns, you're not going to be able to look inside envelopes, right? So any sort of fake checks you found would be excluded, right? Even though you had the right to be in the house searching.
Right.
So if you have a right to search for something for 25 days of CSLI and you found something on the 28th day, that should be excluded. I think you can parse it that way.
But the guns come in.
The guns come in.
And so if you have 30 days and you only have PC for one, why does the 1 day not come in?
Because in this case, the court has basically said, well, I see your argument, but what I think is because you've got a different type of invasion of privacy, you're basically tracking someone for a huge amount of time. I mean, you're searching in a finite space, so the analogies are not perfect between the two types of searches, right? GPS, CSLI, this is extremely intrusive tracking on a moment-by-moment basis. So the idea is you need to have probable cause. And, there's so many easy ways for the government to avoid these negative consequences. For instance, just asking for the stuff you have probable cause for would be a great way to begin. Here they didn't actually have probable cause. It would have theoretically been easy for them to have built it if they had just interviewed the Hernandez family members about his phone carrying habits, or perhaps since they digitally extracted data and looked at all his calls from an administrative subpoena, And that strongly suggests they didn't have any phone use, they didn't have any calls that suggested he was using his phone around the time of this crime. Otherwise, presumably, that would have gone into the warrant affidavit.
Do you think it's an open issue, or is it, I can't tell whether Easterbrook decided this issue that you and the chief are talking about, and I raised earlier, or not. Is it open, or?
I feel that it's open because what Easterbrook said was that, like, say you only use 5 days at trial, that doesn't matter if you needed a warrant because or say you only used the 6 hours under the Stored Communications Act at trial. Well, you still have to either justify or lose your evidence if you had a warrant that reached this broad period of time they need probable cause for. That's what that case
Facts in
decided.
Easterbrook, they requested CSLI for how long? I can't remember.
I believe it was 30 days.
So it was
30 days seems to be kind of like the
They asked
go-to.
for,
with
so they
these
asked for
warrants.
30 days, and then how did we rule on the 6 hours? That the 6 hours, they
The
could.
court held that 6 hours was available just under the Stored Communications Act standard, but it said in this particular case, I believe, that, because you needed a warrant, you got a much longer period, you needed to justify it under the probable cause standard.
And wasn't that limited to telephone CSLI as opposed to registration CSLI?
I'm going to have to beg ignorance on that. I'm not.
You know what
100%
kind
sure.
was requested here?
It was all locational data, so.
I know that, but I mean, there are two different kinds. There's one that's telephone and one is registration.
I'm going to go with telephone. I'm looking over to the proponents of the warrants, and I'm not getting any signal, but I can let the court know.
Signals, huh?
I'll have to take a look at that. I probably have to consult an expert, frankly.
Thanks.
Can you go, I know your time is up too, can you go to Mr. Bennett's point with regard to, let's assume for the moment, I don't know whether it will be, let's assume for the moment that we sustain the judge's finding that the confession or that the statement is suppressed. And then the question is whether or not we strike everything from it, including the consent from the warrant. Is it your view that the telephone number is a fruit of the Miranda violation? He says no.
I'd say it's absolutely a fruit of the Miranda violation because that itself is a statement that's given in the context of the unwarranted interrogation. It's not actually even a fruit of the consent because it's not given, it's not actually material that's removed from the phone.
But the warrant doesn't, the warrant says, at this time, initial check of the cell phone revealed the registered phone number to be Boost Mobile, blah, blah, blah. Then it says they did an administrative warrant for that number. Certainly, they could have obtained the number through other sources, and they may have obtained it. He says they obtained it at booking, I don't know, but
Well, I mean, there could be
how do
further
we deal
motion
with that?
practice about that, but the general rule is that if you use an unlawful means to access something, the fact that you had an alternative lawful way to get it, you're not going to get an inevitable discovery entitlement to that because we're going to try to de-incentivize your initial violation.
But he was booked before he was interviewed, wasn't he?
He may have been. I mean, all we have in this record, I should say, I don't know that he gave his phone number at booking or not. I mean, my brother is the trial counsel, so he may have a better sense of that. But the point here is that when you look at the warrant affidavit, it says, with this information obtained pursuant to his consent, the Hampton District Attorney's Office sent a administrative subpoena to Sprint Corporation. So that's how they're reporting getting the information. Now, whether or not they had some alternative source of it is unclear. I think the point really is for the CSLI, it's obviously excluded from the warrant for purposes of considering the warrant. The separate question of whether it's a straight, direct fruit of the consent, I mean, from the record we have, it is. The government can attempt to go back to the trial court and make an alternative argument, and that can be decided by the trial judge.
So let's assume you're right. It happens sometimes.
That's a fair assumption.
And let's assume we strike the warrant because we say it's tainted by it. Can they generate a new warrant that's untainted based on
I say
information?
they can't basically because the court has said once you've violated the Fourth Amendment or Article 14, you're not going to go back and get an inevitable discovery entitlement because you could have gotten a warrant the
I'm
right
not saying
way.
inevitable discovery. I'm saying they actually generate a new warrant.
Well, if they generate a new warrant, I suppose it would have to be addressed under its four corners, but I think there's a strong argument that you're not going to, once you've unlawfully accessed material, you don't get to kind of give it back, pretend ignorance, and then issue the good warrant. You should do your job right the first time and establish probable cause to seize the stuff you want to seize.
But what if they had his telephone number even before the interview?
I think that would be a relevant fact. For the administrative subpoena only. Not for any sort of logical extractions or anything like that. You're not going to go back and get another CSLI warrant.
Well, that's my point. Why can't they?
because they've already violated his rights, they already have the material. That's, I think, an inevitable discovery argument. To me, maybe we're just in nomenclature disagreement here.
So they suppress that, they give it back, and they say, okay, go back to the company, we'll give you now a clean warrant, and we'll get the same information again.
Right, so I think that what they're trying to do is bootstrap themselves, into a legitimate search from an illegal search, so that they shouldn't be permitted to do that. I mean, if that warrant.
I guess my point is, why is it tainted? If they basically now obtain PC with a totally untainted affidavit, they get
Totally
it.
untainted, meaning that they somehow go back and put together whatever information they need to establish cell phone use at the
Without
time.
any, right, without any taint from them, from whatever they learned from the Miranda interview.
Well, I mean, I see your argument. I just disagree with it because I think what you've got is a situation where the rationale of the exclusionary rule is only served if once you've violated rights and gotten evidence unlawfully, you can't go back and do it right the second time. I mean, that we're not here to basically correct and say, okay, no, now you can get the stuff. We're here to say, this is how you need to, conduct your investigations consistent with people's rights. And once you've violated them, you're going to lose that evidence,
but the
but next
exclusionary
time
rule-
in a different case, you'll have the opportunity to do it right.
Exclusionary rule means that you had a Miranda violation, you suppressed all that derived from that.
Right.
You had a inadequate affidavit because it was too little with probable cause because of it, once you eliminate the tainted information. Why is it not in keeping with the spirit of exclusionary rule to say if you can generate an untainted affidavit with probable cause, that's okay?
Well, I mean, it's obviously, we're in an unusual pretrial posture here, but I mean, I think it's, the problem is that it encourages them to be fast and loose, knowing they can go back and do it, right the second time around. So, I mean, you're not, some of the policies underlying the exclusionary rule are about actually feeling consequences of your violation of people's rights, so that when you move forward, you do things correctly the next time. If you can violate one person's rights and still get the stuff from them because they were able to fight back and show that their rights were violated, I do think some of the policies underlying the rule are not served there.
Okay, thank you.
Thank you very much.